Well, this case is another case from Chapter 11, and basically what we're going to be talking about here is a little bit more on socialism, but it's also more on the First Amendment. The case is called Gitlow, which is G-I-T-L-O-W, versus the state of New York. And there's really a couple of different issues here, and I want to alert you to both of them. One of them is that there's a question about whether the First Amendment should even be applied to the states. So this is the threshold question that they ask, can the states make it up as they go along, or do they have to follow the First Amendment? Well, now today, in our current times, we know that the answer is yes, the states have to follow the whole Bill of Rights, the first 10 amendments, and the reason for that is through the 14th Amendment. There's a whole series of cases in the 1960s that said that the Bill of Rights applies to the states through the 14th Amendment that was passed after the Civil War. And that is because of the due process aspect, which we'll talk more about as we go along. Due process is the right of every person in the United States as a U.S. citizen to have what we would call a fair trial by an impartial, hearer of the facts, whether that's a judge or a jury. Sometimes we may say, well, I'm not just exactly how impartial that person was, but if we don't have any clear evidence, then there has to be an assumption that that person was neutral party, or neutral magistrate, as we call it. Other rights are the right to an attorney, the right to call witnesses, the right to cross-examine witnesses. Now, the jury trial is only a partial right, because in the common law traditions of England and then later the United States, there are certain kinds of cases, what we call cases in equity, that do not include the right to a jury trial. Only cases at law have a right to a jury trial. Well, cases at law are just about every kind of criminal case, and so that would be meaning that even misdemeanors have an inherent right to a jury trial. But in this particular case, once again, socialism is the issue. The year is like 1926, I think, 25. Basically the whole thing went on from like the early 20s up to the mid-20s. And so the main thing is this Gitlow is a far left-wing advocate of the Socialist Party, and really he's calling for the overthrow of the government because the working class, once again, this is one of these situations where extremists, that were involved were trying to get control of unions and the working people, and so that's always kind of put a mark on unions, even though I believe that unions do an important thing even today in our society as a bargaining unit to try to sort out the relationship between the worker and management. But anyway, in looking at this then, the decision was that yes, the First Amendment does apply, but basically, one of the things is if there is a dangerous tendency, according to these early courts in the 1920 range, this dangerous tendency, the overthrow, even just discussing the overthrow of the government, made politicians and even judges nervous back in that day. And so, we had several presidents murdered by this time, some by anarchists, and so they're seeing this as a very bad situation, a bad climate. The other thing you've got to remember is that the Archduke Ferdinand was shot, and that's what started the First World War, and then the Tsar was murdered by basically Marxists, communists, or socialists. They're all kind of interchangeable. At least in these people's mind. They're not interchangeable in my mind. But regardless, at the time, it was a volatile time. We'd just been through a war. There was this attitude, well, we have to be very safe, very careful. And so here again is this weighing of freedom versus safety. Freedom versus safety. In other words, we want our country to be safe, so we're going to stop people from advocating an overthrow of the government. Now this is all going to change. In the 1960s, we'll see a series of cases. Two of them that I can tell you is Brandenburg, which is out of Ohio, and in that case it's a Ku Klux Klan thing. They're advocating guns and this type of thing. And in another case at Indiana University, matter of fact in Bloomington, there's a case of Hess versus Indiana, very important case that we're going to talk about. Not actually listed, but it is mentioned in the same speech as we give regarding Brandenburg. So in the 60s, everything shifted away from so much about this dangerous tendency to more of a more true, exact, clear and present danger approach. Clear and present danger is they had to have the means, the ability, they were in the process, they were making steps toward overthrowing the government. Basically, this dangerous tendency is just, well, that's a dangerous idea. That's all. And so someone says something you don't like, and you can somehow interpret that to be an attack on the government. I don't like Obama. I don't like Bush. I don't like this. I don't like that. Well, you could be slammed in jail for that in 1925. You know. And so times change, things change. I've told some of you that I read this book about the life of Thomas Jefferson. He was extremely upset by this thing called the Alien and Sedition Acts around 1800. From 1800 to like 1803. And that was anybody that wrote anything or spoke anything against the government went to jail. Just like that. You said anything against the government, you went to jail. And so clear violation of the First Amendment, and we would never do that today. But in this time, around the time of war, things do change when there is a war. And so we have to be careful that we say never. Because it could happen again, I suppose, in a situation. But the question is always, you know, is this just an idea, like a dangerous thought, or is it a clear and present danger where they have, you know, dynamite, where they have guns, where they have, you know, some means of enforcing their ideas other than just words? If it's just words, the current view is they're allowed to say it. Well, poor old Mr. Gitlow, that wasn't the way it was back then. So in the Gitlow case, 268 U.S. 268 U.S. 652, a 1925 case, Mr. Gitlow went to jail, and he stayed in jail. So that's basically how that case came out. Well, we'll be back at you with some more of these cases as soon as possible. We'll put one up, like I said, every week. We'll have at least 16 of these video lectures. Hope this was good. Hope you enjoyed it. We'll be back at you with some more later.